This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about why failure to plead an identifiable theory of liability requires a court to dismiss a lawsuit, and that when an insurer settles a claim against the insured for less than policy limits, it fulfills its obligation under the policy. This post 4916 is about dealing with people who are unhappy with their insurers. Raymond Kvalvog challenged the dismissal of his claims against his insurer Secura Supreme Insurance Company. Kvalvog argued that his complaint states a claim upon which relief can be granted because it alleges Secura 1 breached its duty of good faith by failing to inform Kvalvog of his right to withdraw from the liability coverage he invoked and take over his defense, and 2, breached its duty of good faith by failing to properly evaluate the claims against him, and 3, failed to pay Kvalvog $17,500 in uninsured motorist benefits. In the suit entitled Raymond Kvalvog v. Secura Supreme, the Court of Appeals of Minnesota on October 14, 2024, resolved the allegations. After a tragic automobile accident where Kvalvog's son was driving an automobile as part of a high school athletic trip, the passengers in the automobile included his other son and Mark Schwandt. As a result of the accident, Kvalvog's sons died and Schwandt was injured. At the time of the accident, Secura provided automobile insurance coverage to Kvalvog that included liability coverage. Kvalvog brought a wrongful death action against, among others, the school and a coach who was driving a different vehicle as part of the school trip, only to lose. Schwandt later commenced a separate action against Kvalvog, the school, the coach, and Schwandt's own insurer, the underlying action asserting that, in part, that Kvalvog was liable for Schwandt's substantial injuries. Kvalvog tendered the defense of the underlying action to Secura, which appointed a lawyer to defend Kvalvog. The case settled at mediation, when Secura paying less than the policy limits in exchange for a release of all claims against Kvalvog. The district court granted Secura's motion to dismiss, reasoning that Secura had the right to settle the claims against Kvalvog, did so within its policy limits as required by the terms and conditions of the policy. Kvalvog, however, asserted that his complaint supports 3 theories of liability, the first 2 of which are premised on Secura's claimed breach of its duty of good faith. The district court granted Secura's motion to dismiss, determining that Secura did not breach their duty of good faith by settling the claims at mediation within policy limits, and that the complaint did not state a viable claim for $17,500 in uninsured motorist benefits, since he wasn't even there at the time of the accident. The decision of the Court of Appeal resulted when it looked at a complaint that is subject to dismissal if it fails to state a claim upon which relief can be granted. Kvalvog's complaint failed to state a legally sufficient claim that Secura breached its duty of good faith. An insurance policy, like other contracts, is governed by its terms. But Minnesota law imposes an additional duty of good faith on a liability insurer that assumes control of the right of settlement of claims against its insured. This duty arises because an insured and an insurer may have conflicting interests, with an insurer being obligated to represent the insured's best interest and to defend and indemnify, while also wanting settlement at the lowest possible figure. An insurer's right to control the negotiations for settlement must be subordinated to the purpose of the insurance contract to defend and indemnify the insured within the limits of the insurance contract. Secura, the court concluded, did not have a duty to inform Kvalvåg that he could withdraw from the coverage he invoked. A liability insurer's duty of good faith springs from the purpose of the insurance contract to defend and indemnify the insured within the limits of the insurance contract. If an insured is clearly liable, the insurer must attempt to settle within that policy limit with the injured party. A liability insurer's obligations are tethered to a purpose, protecting an insured's financial interests and ensuring that the insured receives the full benefits it is entitled to under the policy. This it did when it settled. Creating the duty advanced by Kvalvåg would do the opposite. Such a duty would run counter to the insurer's other rights and obligations. Kvalvåg has not stated a claim for breach of the duty of good faith on which relief could be granted. His theories of liability failing to advise him that he could fire the appointed lawyer are not viable under Minnesota law, and without an identified liability theory, the complaint does not provide fair notice of the basis of Kvalvåg's uninsured motorist claim, and it was properly dismissed. In my opinion, liability insurance provides for a defense of the insured. It does not, nor should it, provide for the insured's attempt to gain a judgment against the third party or coverage when the responsible party is insured and when he was not injured in the accident. No good deed was punished. Secura settled the claim against Kvalvåg only to be sued for doing what the policy required it to do. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll also have access to the more than 4,900 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And the videos are also free. And if you're interested in further detail about insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.